Super. Can I welcome you all to the final of our New G Pensions lectures for 2021. Today we're looking at some recent developments in the case law which is relevant to the pensions world and which so far might have passed you by. Our first talk is on recent cases from the tax tribunals, which will be given by Emily Campbell, and this will be followed by Robert Ham QC and David Pollard, who will give us an update on pension trustee companies following the Lehtimäki case. We're very keen that today should be interactive and we welcome your contributions, and we encourage you to use the Q&A button at the bottom of your screens to ask questions throughout the session. Please avoid the chat button if you can. You can ask questions anonymously if you wish to, and our aim is to answer all the questions at the end of both of the talks. So I will now hand over to Emily.
Thank you, Paul. Sorry, I'm just going to share my screen. Hopefully you can see that. So the purpose of this talk is to summarize a number of recent cases which it's well worth pensions practitioners knowing about. There are a number of cases involving the charging regime under the Finance Act 2004, crossing the desks of the judges for the tax tribunals, that is to say the first tier tribunal and the upper tribunal. The first two cases I'm going to talk about are from the upper tribunal, and the last two are from the first tier tribunal. It's relevant to bear in mind what the precedent value of upper tribunal decisions is. The upper tribunal is a superior court of record under the Tribunals Act 2007. This means that its decisions have the same precedent value as decisions of a High Court judge. The same cannot be true of first tier tribunal decisions, although they're bound to bear some weight as an analysis of the case by an experienced tax judge following arguments at an oral hearing. Now, often the cases are fully argued by counsel, and therefore one can draw a distinction between first tier tribunal decisions and decisions of the pensions ombudsman. I have had recent experience of an apparent practice of HMRC not to appeal first tier tribunal decisions which it loses and thinks are wrong, and simply to ignore them when dealing with other taxpayers. And I was talking to Robert yesterday about this, and I think Robert, you've had a similar experience. Robert, you're on mute.
Sorry. Yes, I have come across this a couple of times, and it's very frustrating for clients to have to go through a process which somebody else has already gone through.
And it's seriously questionable whether this practice is consistent with public law duties and the HMRC Charter, in particular the requirement to treat taxpayers fairly. Of course, allowing a first tier tribunal decision in favour of one taxpayer to stand and then disapplying it to other taxpayers is capricious because it leads to materially identical taxpayers being treated differently. So moving on to my first case, this is a case of HMRC and SIPPchoice. The question was whether in specie member contributions were eligible to tax relief as contributions paid under the Finance Act 2004, section 188. For individuals, consistently with HMRC manual guidance at the time, which has subsequently been withdrawn, purported to contract to pay particular sums of money to a SIPP, so a sort of form of IOU to the scheme, so that their subsequent transfer of shares was in satisfaction of those money debts. The shares were not eligible shares within section 195, which gives relief on the transfer of shares in certain situations connected with employee benefits. The first tier tribunal held that contribution paid was wide enough to cover a transfer of assets in satisfaction of the debt. The upper tribunal allowed HMRC's appeal. Contributions paid in section 188, according to the upper tribunal, was restricted to contributions of money, whether in cash or other forms, having regard to the provisions of section 195. I think basically the tribunal thought that there was no purpose to 195 if share transfers qualified anyway. The extended meaning of payment with which we're all familiar in section 161 to include a transfer of assets was expressed under the Act to apply to a different chapter of Part 4. So it was not applicable to Section 188. A pre-existing contractual obligation to pay could not convert the transfer of shares into a relievable contribution. And the tribunal held in any event there was no binding contractual obligation to pay on the facts of the case. The taxpayers in SIPPchoice did not, however, seemingly put an available argument, namely whether an IOU itself could be a relievable contribution, or at least if it was put, the argument was not properly understood or dealt with by the upper tribunal. HMRC guidance, as some of you might be familiar with, was predicated on the fact that HMRC never accepted that in specie transfers were relievable per se, but they came up with a series of steps to enable that to be so. The first step was the creation of an IOU, and then there was a step of the transfer of assets in satisfaction of the IOU. I mean, it might be thought that whoever drafted that guidance had an idea that it was the IOU itself which was equivalent to money. If the IOU was equivalent to cash, then that would be the relevant contribution, and the subsequent satisfaction of the IOU by the transfer of shares would either be an authorised or unauthorised member payment, depending on, in particular, the value of the asset that was transferred. HMRC is clearly rightly concerned about members or indeed employers offloading junk assets into their scheme in order to obtain tax advantages. I have, for example, seen some particularly egregious examples involving intellectual property rights, whereby the valuation methods seem to involve a form of magical thinking. There was no exploration in SIPPchoice of what forms of asset other than cash might count as a contribution in money, although the judgment does explicitly say money in cash or other forms, thereby suggesting that there are other forms than cash that count as money. And it must be remembered that schemes never actually receive cash. No one turns up at the pension scheme with a sack of cash. Usually what the scheme gets is an IOU from the transferee bank. So if you are paying, as many people do, member contributions using a SIPP, say, using direct debit, what you're actually transferring to the scheme is an IOU from the bank. Now, the question of whether an IOU is a relievable contribution as a contribution in money is being heard as a preliminary issue later this year, in a case in which I'm acting for the taxpayer on the instruction of Burgess Salmon. So it'll be interesting to see what the result is, and watch this space. So moving on to my next case, this is a case of Bella Figura, another upper tribunal decision. The case concerned an unauthorised employer payment, namely a loan. In principle, this gave rise to an unauthorised payment charge, surcharge and scheme sanction charge, i.e. the full suite of three. All three fell on the employer in this case, in the case of the scheme sanction charge in its capacity as scheme administrator, in the other two cases in the capacity as employer. The principal in question was, one, whether it was too late to assess the unauthorised payment charge and surcharge, and two, whether it was just and equitable to discharge the unauthorised payment surcharge and scheme sanction charge under section 268 of the Act. The upper tribunal's decision was delivered by our very own Mr. Justice Newgy. The upper tribunal rejected a technical argument that, owing to a drafting anomaly, there was no power to make assessments at all in respect of the scheme sanction charge. Regulation 4 of the Registered Pension Schemes Accounting and Assessments Regulations 2005 provided a standalone power to make assessments. As to time limits, both parties agreed that the applicable time limits for making any permitted assessments were set out in section 34 to 36 of the Taxes Management Act 1970. HMRC needed to show carelessness in order to evoke the 6-year period for making discovery assessments rather than the usual 4 years. For some reason in this case, HMRC had raised an assessment for the scheme sanction charge in March 2015 and for the unauthorised payment charges later in October 2015, the cut-off point for the 4-year period being April 2015. The upper tribunal held that the employer had not been careless in relation to its reporting duties. Indeed, it looks to me like HMRC was the one that had been careless by not bothering to timeously issue unauthorised payment notices when it became aware of the loan. Even though no express advice had been obtained by the employer, it had been reasonable for the employer to derive reassurance from the firm of pensions administrators which had prepared the relevant loan documentation and who had not suggested it was defective. Accordingly, it was too late to raise a discovery assessment in respect to the unauthorised payment charge and surcharge. Finally, the upper tribunal declined to discharge the scheme sanction charge on the basis it would be inappropriate for there to be no consequences at all for the loan. So the implication is that had it not been for the time limit issue, that it might otherwise have been inclined to do so. Now, Figura is a very useful case in that it shows that an honest taxpayer can escape even the basic unauthorised payment charge on the basis of HMRC delay in discovering the issue, and that the taxpayer can contend against carelessness on the basis that he, she, or it reasonably relied on another party, usually a professional, in making the error. Now, I have had experience of HMRC practically disregarding Figura in a case involving taxable property and seeking to circumvent it by contending that the acts of an advisor or of the scheme administrator should be attributed to the taxpayer under the principles of agency, which is, if it applies, permissible under Section 36 of the Taxes Management Act, which refers to the attributing to the taxpayer of acts of another person acting on behalf of that person. There is authorities to suggest that, well, that makes clear that giving advice is not acting on behalf of for tax purposes. And actually, amusingly, the case in question was drawn to my attention by the Revenue, who are relying on it as authority for precisely the opposite proposition. And it seems to me, anyway, that the argument that scheme administrator in the ordinary discharge of its duties as scheme administrator is acting on behalf of the member as agent is wrong as a matter of basic pensions law. But this is one of the examples of HMRC losing a case and then just ignoring the decision. And I mean, what's particularly egregious is this a decision of the upper tribunal. Moving on, the next case I want to refer to is a case of Hymenson relating to mistaken contributions. The taxpayer had obtained a fixed protection certificate, but had not realised that he needed to stop making contributions. Accordingly, HMRC revoked the certificate on the basis that there had been benefit accrual contrary to the requirements set out in the Finance Act 2011. The taxpayer argued that he'd made a mistake when he paid the additional contributions, and that therefore those payments could be set aside and treated as if they had not happened. The taxpayer was successful and HMRC did not appeal. The first tier tribunal decision in Hymanson, the first tier tribunal in Hymanson was with the view that the taxpayer had made a mistake as to the tax consequences of the transaction. If he were to take this case to the High Court, it would issue an order for rescission for mistake under the Pit and Holt jurisdiction. The first tier tribunal was effectively prepared to treat that as done which ought to be done. It applied the upper tribunal case of Lobler by analogy. That case concerned rectification, and the decision of the upper tribunal was delivered by Mrs. Justice Proudman. She stated, thus, although the first tier tribunal did not itself have power to order rectification, it could determine that if rectification would be granted by a court who does have jurisdiction to grant it, Mr. Lobler's tax position would follow as if such rectification had been granted. This is a practical policy decision designed to ensure that the courts are not cluttered up with cases referred by the tax tribunals. It represents an important alternative route to obtaining the tax consequences of equitable relief. I, however, have had experience in 2 different cases recently of HMRC simply saying to the taxpayer that Hymenson is wrong and should be disregarded. One of those cases is in the course of being appealed to the first tier tribunal. That's a case I'm involved in, so there may be a further decision on this topic in the next few months. So it will be interesting to see whether HMRC's backdoor assault on Hymenson and Lobler is successful. Finally, a very recent case of Gammell and HMRC. The first tier tribunal held that a taxpayer who had reasonably relied on the defective advice of his professional advisors had a reasonable excuse for failing to apply for enhanced protection of his pension against a lifetime allowance charge by the due date under the Finance Act 2004. He had acted promptly once he became aware that a late application was possible and therefore should be entitled to make a late application. So I would refer to the Gammell case as well as Bella Figura, showing that the tax tribunals are sympathetic to taxpayers who have reasonably relied on incorrect professional advice. Seemingly, however, HMRC are not. I mean, if HMRC had looked at the facts in these cases and had looked at it in the same way as the tribunal subsequently did, then there would never have been an appeal to the tribunal. So HMRC are clearly uncomfortable with the idea that taxpayers can, to any extent, blame others for mistakes that have been made. However, HMRC's approach in this regard does not appear to be consistent either with the terms of the relevant statutes or with the growing body of authority. So that's all I wanted to say. And back to Paul to introduce the next talk.
Thank you very much, Emily. I'll now hand over to Robert Ham QC and David Pollard, who are speaking on pension trustee companies, an update following the Lehtimäki case.
Thank you, Paul. We're going to go a little outside the ordinary field of pensions law. So perhaps I could start by telling you something about the factual background to the case and what it decided. And David will then turn to the question of what impact it might have on pension trust scheme trustees.
Although we're going to heckle each other as we go through, aren't we?
We are. And I'm going to use you as the person who switches on the slides and moves them, I hope. Right. This is the case of Lehtimäki and Cooper, which is going to appear in the official law reports under the name Children's Investment Fund Foundation UK and Attorney General. I'm going to call it the SIPP case, which is the acronym which is used for this company. It's a charitable company limited by guarantee. It has had 3 members, Chris and Jamie Cooper Hone, as they were at the time when the company was established, a married couple, and their old friend from Harvard Business School, Marco Lehtimäki. Without intending any disrespect to 3 highly intelligent and deeply serious individuals, I'm going to call them Chris, Jamie, and Marco. SIPP is a charity whose focus is on helping children in developing countries. It was set up as the intended recipient of the bulk of the profits of a hedge fund called the Children's Investment Fund, set up at the same time and intended to be managed by Chris. SIPP has been TCI has been enormously successful. It's one of the top 20 hedge funds of all time. The latest figures I've got for the net return after fees were for 2020 14%, 2019 41%. For the years down to and including 2018, an average of 18%. In round figures, $1 billion flowed from TCI to SIPP, which was then invested with TCI, which turned the initial billion into something over 5 billion, and I expect it's rather more now. Unhappily, the marriage between Chris and Jamie broke down. One of their major interests in life was the charity SIPP, and understandably, Jamie wanted to continue to be able to be involved in charitable affairs. And basically what she would have liked was half of SIPP, but the family division judge held clearly correctly that it wasn't a matrimonial asset, and there was no jurisdiction to do that. Now, SIPP had the usual two-tier management structure of members and directors, or as they were called in the articles, trustees. As well as being members, both Chris and Jamie were trustees, that is, directors. And after their divorce, their differences proved somewhat disruptive to the management of the charity. Eventually, it was agreed in 2015 that Jamie would resign as member and trustee from SIPP, and that it would make a grant of $360 million to a new charity set up by her called Big Win Philanthropy. However, the trustees stipulated that the application, that the grant should be subject to court approval, and it's their application for approval that ended up in the Supreme Court. Next slide, please, David. We've said on this slide that the directors surrendered their discretion. In fact, they applied for approval, and one got the situation that is not uncommon when it wasn't clear whether they were asking the court to bless a decision that they'd already taken or asking the court to take their decision on their behalf. Eventually, the conclusion was that it was a surrender of their discretion. Now, at the time of the agreement, nobody identified that under the extended definitions in the Companies Act, the grant to Big Win was to be treated as a payment in connection with Jamie's loss of office, and therefore required member approval. Chris and Jamie agreed not to vote on the basis that they were conflicted, though, as David queries, it's not entirely clear that that was right or that they were disenfranchised. But in practice, the member approval came down to how Marco voted. Next slide, please. First instance, the Chancellor added Marco, who hadn't been made a party to the proceedings, without giving him an adjournment or any opportunity to take proper advice. Marco has consistently said that he hadn't decided how he would vote because the Companies Act procedure envisages a decision by the directors, because it's a charity, approval by the Charity Commission, and only lastly, a member approval. Next slide, please. Sorry, I'm jumping ahead. The Chancellor decided that Marco was a fiduciary, and though the Chancellor found expressly that others might reasonably take a different view, he concluded it was in the best interests of SIPP to make the grant and directed Marco to vote in favor of approval. Next slide. Marco took this to the Court of Appeal, which allowed the appeal, agreed Marco is a fiduciary, but applied the non-intervention principle, that the court will not in general substitute its view for decisions of trustees and other fiduciaries. Next slide, please. I think my text is going to slightly diverge here, but the Supreme Court agreed with both lower courts that the member was a fiduciary, but notwithstanding the non-intervention principle, it reinstated the Chancellor's order directing Marco to vote in favour of the grant. There are two opposing judgments, but at this stage, it's worth noting that both analyses depended on the finding that Marco was a fiduciary. The court could only intervene if he was a fiduciary. If he wasn't a fiduciary, it had no jurisdiction whatsoever. I will pass over the question of whether there was Marco was a fiduciary, because there was unanimity in the courts. It's normally the principle that the members of companies aren't fiduciaries, and interestingly, Lady Ardens said that applied to companies without a share capital as well as companies with a share capital. But it was different where the company was a charity, or might be different. And in that case, in this case, she found that the members of SIPP were fiduciaries and owed the duty, not as one might expect to the company, and the view which the Court of Appeal took, but to the charitable purposes of SIPP. Now, I'm not going to go into the arguments against holding that the member of a charitable guarantee company is a fiduciary. I don't know if he's going to speak to it, but David deals with that in some detail in the draft paper which he's prepared. It's potentially significant that just pausing there, one occasionally comes across corporate trustees of pension schemes which are guarantee companies. I think that is relatively unusual. But if the members of a charitable guarantee company owe fiduciary duties to the purpose of the charity, why shouldn't the members of the pension scheme owe duties to the members of the scheme? And how does that fit in with the well-established proposition in the case of the other tier of governance of the company, the directors? Duties are owed to the company alone. Now, as I've said, there were two strands of reasoning. Four of the Lord Reed, the President of the Supreme Court, found this judgment of the Court of Appeal more persuasive than the other members of the court, but didn't push it to dissent. Four of the others, three of the others, Lord Briggs, Kitchen, and Wilson, took one view, and Lady Arden took another view. But note that though the gang of three decided the case on a different basis to Lady Arden, they, I think, accepted her analysis, except on the one point in which they differed. The majority held that the fiduciary member was bound to follow the court's judgment, that making the grant was in the best interests of SIPP. The fact that Marco hadn't surrendered his discretion didn't alter the position. It was a decision once and for all that this was the right thing for the charity to do, and for that reason, he was duty bound to do so, and if he didn't, there was a breach of duty. Lady Arden took a different route. She said that this was a case where there were exceptional circumstances falling within an exception to the non-intervention principle. To my mind, Lady Arden's response to the Briggs judgment is wholly convincing. The duty of fiduciaries is subjective to do what they in good faith think in the best interest of the beneficiaries, or in this case, the charitable objects. It's the fiduciary, not the court, which makes the decision. The question isn't the objective question, what is in the best interests of SIPP, but does the fiduciary in good faith consider that the transaction is in the best interest of SIPP and its charitable object? As I say, Lord, can I go to the next slide, please, David? Lady Arden's approach was different. She said that this was an exceptional case of exceptional circumstances where the court was able to intervene. There were two strands to her reading, her reasoning. First of all, that the court has a wider jurisdiction over charities than other trusts. And secondly, that there was a threatened impasse in the administration of the charity. If Marco weren't able to bless the grant, because the charity would then face an existential threat because of the dissension between Chris and Jamie. That's right up to a point, but on the facts, the agreement that had been reached involved Jamie resigning as a member and trustee, whether or not the court approved the grant. So the existential threat had been removed, whatever the outcome. I just want to say a word about the test for determining whether there are exceptional circumstances enabling the court to intervene. In the famous 19th century case of Lehtimäki and Brewers, the Privy Council described the jurisdiction of a court of equity to remove trustees as merely, and I quote, ancillary to its principal duty to see that the trusts are properly executed. That, I suggest, is the criterion to be applied in deciding whether intervention is justifiable in the absence of a breach of fiduciary duty. I want to finish with this. David, as I say, is going to look at some depth at the impact on pension trustees, but I do want to make one litigation related point. Even non-litigators, I think, likely to be familiar with the fourfold categorization of applications for directions by trustees made by Mr. Justice Robert Walker in the unreported case of Egerton Trust Retirement Benefit Scheme, the categorization made famous in Public Trustee and Cooper. And the distinction drawn there between categories 2 and 3, blessing momentous decisions and surrendering of discretion. In practice, it's often not altogether clear on into which category a particular application falls, but SIPP shows that this is important because the fact that it was held a surrender is a critical point in the reasoning of Lord Briggs and those who agreed with him. And I just want to say one further word about Egerton Trust, which is for a particular potential participant in this webinar that Egerton Trust was a case where the scheme actuary was the individual who gave me the idea that it was a money purchase scheme. If it was a money purchase scheme, you didn't need an actuary and vice versa. Thank you. David, now over to you.
Thank you, Robert. Right, so we've got Lehtimäki. I'm going to call it Lehtimäki, partly because that makes it easier to search, although you do have to do an A umlaut, which I find quite difficult. There's probably a button here that does something. So this is a charity case. This is a series of pensions lectures. Why are we looking at a charity case? Well, we're particularly looking at pension trust companies. It's pretty common to have a trustee company now rather than a group of individual trustees. In fact, it would be rather odd in a trust of any size, a pension trust, to not have a trust company. There are various ways that helps, in particular contractual liability, particularly with trustees entering into longer term contractual engagements like swaps and things like that. Lehtimäki is a case involving a trust, a company, a charitable company. It talks about charities all the way through, so it's definitely a charity case. It's slightly different. There's no express trust, I don't think, in Lehtimäki. It doesn't actually point this out terribly clearly, but what it is a company that's got charitable purposes. So it treats the directors as though they were trustees, and there are indications about that in the Charities Act, but only for statutory purposes. But when looking at this issue that arose, what was the position of the member in giving their vote and things like that, looking at it under the Companies Act, but it was in a charity context, and all the courts went back to the basic law of trusts and the basic law of fiduciary. So it's a really important case in the Supreme Court on those sorts of issues, and it's going to be the source of, it's the source people are going to turn to and look at and point to, and I'm going to come on and say, well, what does this mean for pension trust companies? It's not a very easy case in terms of the facts are fairly complicated, and also the decision in the Supreme Court, 3 judges going one way, 1 judge being agreed with for most of the argument. It looks, the judgments look a bit like a traveling draft, so you get Lady Arden doing a first draft, and then the other 3 going, well, we agree with that so far, but here's a quick route out of it. And then Lady Arden going, I don't agree with the quick route. And then the 3 judges coming back going, well, we still don't agree with why Lady Arden doesn't agree with us. And then Lord Wilson saying it was all, he preferred the Court of Appeal, but wouldn't actually write a judgment. So it looks at, in particular, the basics. It looks at who is a fiduciary, was the member a fiduciary in this case? What are fiduciary duties? What are the duties that this fiduciary owes? And there's quite a lot of interesting stuff on that in the case. So a member of a charity, which apparently would include a mass member charity, at least according to Lady Arden. You can't vote for yourself to be a director, according to Lady Arden, because they've got a fiduciary duty and you can't vote for yourself. So what are the fiduciary duties going on, and what does this mean for pension trustees, in particular pension trustee companies? So I thought of 5 issues, and I'm going to address the first 4. Are the shareholders fiduciaries? So what's the position of the shareholders in this pension trustee company? Are the directors of the trustee company fiduciaries to the pension trust beneficiaries? That's a sort of old chestnut that's been out there for some time. Thought that was settled, really, but how does this case impact on that? Is the employer a fiduciary? Again, issues on employers being fiduciaries in relation to pension trusts. Again, how does Lehtimäki affect that? And can the courts give directions to everyone in a pension scheme, which again is coming back to Lehtimäki, where they did give directions to someone who was before the court, but and a fiduciary, but how did they do that? And then lastly, which I'm not really going to do, what is a fiduciary duty anyway, with the nature of the fiduciary duties? So if you look at those in order, are the shareholders of a pension trustee company fiduciaries? So you've set up there's a pension trustee company. Who owns the shares? In most cases, I think the shares tend to be owned by the employer, but you can have pension trustee companies where the shares are owned by the individuals who are directors, or you can have a pension trustee company, which is a company limited by guarantee. And actually, that's quite a good structure in some ways, because you can change. You don't have to transfer shares when directors change. So the guarantors are in fact the individuals who are acting as directors, who would otherwise be trustees if it was individuals. So I think in those circumstances, I think the decision in Lehtimäki was looking at the position of a member of a trustee company, a charitable trustee, and the decision was by all levels of the courts, the first instance, Court of Appeal, and the Supreme Court, that Dr. Lehtimäki was a fiduciary. And why was he a fiduciary? Well, it was all to do with reasonable expectations. Was there a reasonable expectations of the people involved that the shareholders or the members, in the case of company by guarantee, would be fiduciaries? And Lady Ardens said, well, yes, because look, there's a Charity Commission guidance note on this, and I'm going to prefer that to the fact that the law books on charities said they didn't think, or thought it was unclear whether or not members of charities owed fiduciary duties. So there was a reasonable expectation, and that was enough to make the member of the charity a fiduciary. Okay, so could that apply to a pension trustee company? Well, potentially it could. It's going to be very fact specific. I think in practice it's going to be quite difficult. I'm not sure there are reasonable expectations floating around about the duties of or the position of shareholders in a pension trustee company. But if it did, then a range of constraints would apply. You can't apparently vote for yourself to become a director. You can't exercise powers as a trustee in your own interests. That's the nature of being a fiduciary. So a principal company or an employer owning the shares wouldn't be able to do that. It does mean that you might cease to, the pension trustee company might cease to be a subsidiary of the employer. The definition of subsidiary in the Companies Act says you ignore powers that are held as in a fiduciary capacity. So that's in Schedule 6 of the Companies Act. So that could mean that some of the exemptions that can be applicable in pension schemes, for example, under the Financial Services Markets Act, collective investment scheme stuff, you might have a collective investment scheme that requires an authorized person. There's an exemption if all the members of the scheme, all the participants in the scheme are in the same group of companies. So actually that's relied on by pension trustees in some circumstances, sort of common investment funds for lots of different pension schemes, or these asset-backed security arrangements all rely on that exemption. So this issue could have a potential big impact in some circumstances. Right, number two, what about, I don't know if Robert has any interventions at that stage. Are you happy with that, Robert?
Happy so far.
I'm not holding you to this, I don't think. Are the directors of the trustee company fiduciaries to the pension trust beneficiaries? Well, it's not really mentioned in Lehtimäki. There was an assumption and a principle that in a charitable context, the directors are the same as trustees. Robert said they were called trustees under the constitution of the trust in Lehtimäki. The Charities Act sort of says trustees are people who manage the charity. This was a charitable company without a separate charitable trust, just held its assets on the equivalent of charitable trusts and there's lots of discussion about that in the case. So there's no mention of the case law that discusses whether trustees of a company, which is a trustee, also owe direct fiduciary duties to the beneficiaries of the trust, the members of the pension scheme in our context. So cases that deal with that and look at that, HR and JPT in a pensions context, the later Gregson case of private trust context, are not mentioned in Lehtimäki. Now, the usual issues still apply, that directors can clearly have fiduciary duties, or they owe fiduciary duties to the trustee company, clearly, and those it might end up being enforced down the track, and they might owe an indirect duty if there's dishonest assistance. So if the directors dishonestly assist in a breach of trust by the trustee company, then that can give rise to direct fiduciary duties. There's some discussion in Lehtimäki about the 1950s case, charity case, called Re French Protestant Hospital. And in that case, Mr. Justice Dankworth, as he then was, said that the directors of the charity did owe direct fiduciary duties to the charity, to the members of the charity. And in fact, that meant they couldn't enter into arrangements to pay themselves remuneration. And he repeated that in a later case, but he didn't refer to two earlier Court of Appeal decisions on trustee companies. And it may be this is a charity case rather than a non-charity trust case. And those French Protestant Hospital was considered in HR and JPT, and Miss Justice Lindsay there said no, he had to follow the Court of Appeal decisions. He didn't think he could follow from New French Protestant Hospital. Didn't do that because it was a charity case. So are there reasonable expectations? That's the test that comes out of Lehtimäki about whether someone is a fiduciary. So do directors go round calling themselves trustees, do they say we are really in a position of being trustees? You've got to be quite careful about that. That could give rise to these reasonable expectations. So I think people might be might encourage people to bring cases based on this reasonable expectation point.
David, you say people. It's probably only the Attorney General who can bring such proceedings, or the Commission.
In charity cases.
In charity cases.
What about, I was thinking members or.
Yeah. No, if there's a duty to the beneficiaries, in inverted commas, why shouldn't that be a scheme member as well as the attorney on behalf of charity?
Yeah. Well, I think in a charitable context, it's difficult to see who the beneficiaries are who bring a claim, which is why the Attorney General is the primary means of enforcement, or the Charity Commission. But I think in a pensions context, you might say, well, it's £100 trustee company. I really want to have a claim, and the Ombudsman may have jurisdiction against directors anyway, as people involved in the management, sort of similar to the charity line. So it may be that comes out, but it's a sort of, I think Lehtimäki is a push in that direction on who is a fiduciary. I think overall you get out of Lehtimäki that the courts are quite prepared to find people fiduciaries, and when they might have thought they weren't. And that brings us on to employers. Is the employer a fiduciary? Employer has powers under a pension scheme. Quite often you have this balance of power. It's very similar to a protector in lots of private trust cases. You have powers to agree on transfers, power to agree on amendments, that sort of thing. The employer in a different position to a protector in a private trust, because he's clearly got an interest in the scheme, probably the settlor, or partially the settlor setting it up, and has an interest in funding the scheme. Case law on relation to employers, understandably not addressed in Lehtimäki. There are special cases where employers have been held to have fiduciary duty. So in Metoy, quite a difficult case, and the judge saying, well, I wouldn't have upheld the amendments but for holding that the employer was a fiduciary and may not be followed in these circumstances. And the Supreme Court in Lehtimäki did, Lady Hale mentions not giving directions to non-fiduciaries. The Supreme Court didn't give directions to the Charity Commission, didn't join the Charity Commission into the case and direct it how to decide to give its consent in relation to this grant. So I'm not sure Lehtimäki is particularly adding stuff on this. Interestingly, the case of Skeets, which is often cited as an 1880 case in relation to appointment of trustees, where the judge, Ms. Justice Kay, held that was a fiduciary power in a private trust case, even though not a power held by a fiduciary, it was a fiduciary power. That was cited in the Court of Appeal, but not cited in the Supreme Court, which I'm not overly sure Skeets is rightly decided in that sense, but it has been followed through. So I'm not sure Lehtimäki adds that much into whether an employer's going to be a fiduciary or not. There are quite a lot of cases that say employers aren't generally fiduciaries, Imperial Tobacco, Prudential Trustee, a bit in National Grid, that sort of thing. So, Robert, do you feel?
And I think the footnote I would add to that is that the employer may be a fiduciary in relation to some powers, but not all.
You can be a fiduciary in relation to some powers. There's a Jersey case talking about an employer power to appoint and remove trustees being fiduciary, sort of following that Skeets line and then dealing with only some of the powers of fiduciary. And that doesn't mean you have to disclose your obligation, for example, under the Londonderry principle, but only in relation to your fiduciary powers, not in relation to your non-fiduciary powers. So there is that divide that can come in there. But I think any of the powers being fiduciary is quite interesting. and I'm not sure Lehtimäki takes us much further in that, but you can see people quoting that as a basis for whether there are fiduciary powers. So lastly, can the courts give direction? So say the trustees, as fiduciaries, the trustee company surrenders its discretion to the court about should I agree to an amendment of the scheme, and an amendment requires the consent of the company. Sounds quite similar to should I make this grant, and the grant requires the consent of the member, Dr. Lehtimäki. Or can the court then say, well, we'll join in the company and we'll make them, and then they'll be bound by what we as the court say. It's all fundamentally different to the sort of non-intervention argument about, you know, the power is given to the individual company, in our case, or to the trustees. Why are the courts interfering with it? No, they did. It was a charity case, as Robert said, that so the courts look after charities a bit more. The Supreme Court in Lehtimäki, as I said, did not give directions to the Charity Commission, which might have been a fiduciary sort of floating around there. But, and Lady Arden, in a bit that the other three majority didn't agree with, said that the exceptions only enable the court to make orders to fiduciaries, doesn't enable the court to bind any non-fiduciary, such as a donor beneficiary. So I think that's pointing to the fact that this isn't something that the courts could give directions that would bind a non-fiduciary such as the company or the employer in a pensions context. But who knows in some of this sort of stuff coming through. That's probably going to be our ending thing about who knows. Lord Briggs disagreed with that, but his judgment was entirely based on directions to a fiduciary who in fact was party to the proceedings. And it looks a bit like a deadlock sort of case where the court will intervene if two sets of trustees can't agree anything, which is sort of similar back to Cowan and Scargill. I quite like the case of Re-Equity Court, not cited in this case, was an insolvency case about whether directors had presented an administration petition, and 3 of the directors had voted in favour and 1 had voted against. And the 3 had presented the petition, and Miss Justice Millett said, well, the 4th director, even though he voted against, was under an obligation to carry out the resolution once it had been put in place. So therefore, all the directors had approved the application. So that's a sort of similar position in a deadlock case, although of course the director was a fiduciary as well, not what was said here. So I think probably courts can't give directions, but will someone have a try, I suppose? Do we end up with watch this space?
Yes, we always end up with watch this space. Thank you very much, David and Robert. So we move on now to questions. No questions from participants yet. While you're thinking about questions or comments, I'll ask Emily, if I may. Do you think the fact that non-legal professionals like accountants sit on the first instance tribunals together with judges makes any difference to that tribunal's approach, either generally or in relation to the specific issues you were looking at?
Well, I think where they do sit, they are sitting to assist with the interpretation of facts. However, my experience of tribunal judges is that they're very logical, and people with a tax background found to be very logical, and therefore the quality of the reasoning can be quite high in complex cases. And so I'm sure that if somebody's as a judge sitting with an accountant, it's always good to have somebody to bounce ideas off. But the quality of the decisions is certainly good enough for HMRC and the administration of the tax system to be taken seriously.
Thank you. We now have a question from Philip Bennett for David and Robert. Any thoughts on whether you can draft your way out of being a fiduciary in the article stroke trustee for a pension scheme trustee company, or say expressly you are a fiduciary and then expressly authorised duty stroke duty conflicts?
The answer to that is, in theory, yes. And it is common to, so to speak, contract out of some basic fiduciary obligations. For example, a trustee charging clause is contracting out of the fiduciary obligation of not to benefit from the trust or other fiduciary relationship. Having said that, my experience is that if you try and rely on such a clause, the court may not attribute very much, give very much weight to it. For example, if you have a clause saying that a protector's consent is required to the disclosure of information, and expressly saying the protector is not to be fiduciary, the court will not, in my experience on more than one occasion, really be deterred from ordering disclosure by the existence of such provisions.
I think that there's some discussion in the case about whether fiduciaries whether you could put in the governing document some exclusion from a benefit provision, whether that would work in a charity context where you're supposed to be exclusively charitable. I mean, it's an issue for the National Trust, which has got millions of members, and they get free access to some properties. That's a benefit. If they're a fiduciary, and Nadia said she thought they were, although the courts tended to bounce off mass charities in that context, then I suppose in theory you could put something in the governing document that dealt with whether or not you could have a benefit despite that. And I think that should work, but although the courts might be instinctively against it, and how do you put it in? It can be an issue. If you're a fiduciary, why are you voting for something that benefits you? That can be an issue going through, but there's a Scottish case, Dollar Academy, which is quite helpful on that in some circumstances.
Thank you. And I think we've got one final question from Lauren Cathro to Robert and David, probably more to Robert, given he was more closely involved in the case. Why do you think Marco was so eager to take the case to the Supreme Court?
Because he's a deeply serious person who took his responsibilities very seriously. And I hope I'm not revealing information which I shouldn't, that he came under quite a lot of pressure not to pursue the appeal. But I'm sorry, in the Supreme Court, it was, of course, Jamie who was the appellant. But Marco was under quite a lot of pressure and may rightly or wrongly have felt threatened that whichever way the outcome was, that he was likely to be confronted with a dissatisfied person with very deep pockets who might have a pot shot at him.
Yes, yes. Thank you very much. Well, that concludes today's session. You'll all soon be receiving a short questionnaire in your browser once this session is over. And we really appreciate your views on how you found the session today and any topics you'd like to hear from us on the future. The recording of this webinar will be available to view on our YouTube channel later this week in case you missed any of the session. And you can find that by typing Wilberforce Chambers into the YouTube search bar. As I mentioned at the start, this concludes our 2021 UG Lectures series. Speakers are currently working on their papers and they'll be circulated to all attendees along with slides from all 4 lectures later in the summer. If you have any questions in the meantime, please email seminars@wilberforce.co.uk. So all that remains for me is to thank Emily, Robert and David on your behalf and to thank you all for attending. Goodbye.
Goodbye.
Bye.